Hi, everybody. Today we're going to look at the Supreme Court in action. So, we've learned about how the federal court system is organized and the powers that they have, and we talked about how the Supreme Court works last class. But now we're going to talk about how a Supreme Court case works. Okay, we're going to learn the whole process. If your case makes it to the Supreme Court, what's that like? Let's get into it. All right. So, here are the steps in deciding a Supreme Court case. Step one is you need to request that the Supreme Court takes your case. So you have to file what's called a writ of certiorari. Nobody actually calls it that. People just call it writ of cert because it's so hard to pronounce, but it's a writ of certiorari. Here's an example. Somebody, I don't know what this case is about. This was a petition for a writ of certiorari in some case in 2014. Anyway, you write a letter to the Supreme Court asking them to take your case. So a writ of cert is a request for lower court documents. So most of the time, these cases have already been heard in a lower court. So you want those documents so you can take those documents to the Supreme Court and have a redo with the Supreme Court. So it's used by the SCOTUS to call up a case if they agree to hear it. So if they take your case, the Supreme Court will ask for all the documents from the previous court, the lower court, and use that information when they're deciding your case on appeal. If the Supreme Court decides to take the case, they'll issue the writ of cert. If they decide not to take your case, they'll issue you a denied cert letter. Very simple. So I thought this was kind of funny. Here's what a denied cert letter looks like. Dear Mr. Nowak, the court today answered the following order in the above titled case. The petition for writ of certiorari is denied. That's it. That's all you get. So if the Supreme Court does not take your case, you get a letter that looks just like this. Okay, so the reason why the Supreme Court has to deny cases is they get thousands and thousands and thousands. They couldn't take all of the cases that people want them to hear. So they get all these requests and they have to decide which court cases to add to their caseload. They get an average amount of appeal, about 8,000 cases get appealed per year. 8,000. They can't take 8,000 cases um, a year. So they only accept about 70 to 80 cases per year. That's about a 99% rejection rate. So is it likely that you ever said to yourself, like, I'll take this all the way to the Supreme Court if I have to? That is not likely. There's a 99% rejection rate. So how do they decide which cases to hear? They reject 99% of them. How do they decide what's good enough to be that 1%? Well, the Supreme Court is more likely to hear a case if these conditions are met. Number one, if two or more of the circuit courts, these district courts, they're AKA circuit courts. So, like if a court in New York said yes and a court in California said no about the same issue, well, the Supreme Court is going to be much more likely to hear that case because you can't have a situation where something is legal on a federal level in one part of the country and not in another part of the country. So, the Supreme Court would definitely want to take a case where two different district courts made different issues or made different rulings. If it's the federal government that's petitioning for the case, they're more likely to take the case. So if it's Congress or the president that is applying to have their case heard by the Supreme Court is more likely to hear that case than a regular person off the street. If the case involves the Constitution or the Bill of Rights, which is part of the Constitution, but if the case involves a constitutional issue like a civil liberties or civil rights question, the Supreme Court loves taking cases about that. Or if the case just has significant political interest. If there's a lot of political attention, the Supreme Court will be more likely to take the case to settle the dispute if that dispute is big on TV or out in the streets, like big controversial issues. So the Supreme Court is also more likely to hear the case if it's justiciable, which means the case has to be capable of being decided by the court. So a real thing has to have happened. Somebody has to have actually been harmed or claimed to have been harmed in order for the case to be heard. So you can't sue because you think something bad might happen. You have to wait until the bad thing happens and then you can sue and hope that the Supreme Court takes your case. But the Supreme Court can't take a case based on something that might happen or could theoretically happen. It's got to happen for it to be justiciable, which means being able to be decided by the court. Also, the court has to have standing. So there's certain cases the court is allowed to take and certain cases the court's not allowed to take. So in order for the Supreme Court to take a case, the person that has been harmed has to file the case. Otherwise, they wouldn't have standing. So I can't sue in the Supreme Court for you. If you want to sue in the Supreme Court, you have to be the one that files the lawsuit. Then you can get all your lawyers and all the help you want, but you can't take your case to the Supreme Court on someone else's behalf. All right, now step number two: acceptance of the case. So Again, they get 8,000 requests for cases heard per year. They only take about 70 to 80 per year. How do they decide which ones to hear? Well, they sit in their conference room. Here's a picture of the conference room at the Supreme Court building. There's 9 desks. They sit around the table and they talk about it. And they have an unwritten rule of 4, it's called. So it takes 5 out of 9 justices to win a case, but it only takes 4 justices to hear a case. So if you can convince 4 justices that your case is worthy of being heard by the Supreme Court, then you've got a shot. So, most constitutional court cases, or most Supreme Court cases, involve constitutional questions, or cases that involve great public interest or something with big national importance. If they take your case, they'll add it to the list, and that list of cases is called the docket. Every court has a docket. A docket is just a fancy word for all the cases that the court is going to hear that day or that week or that year or whatever. All right. Step 3. Now, you've applied to have your case heard. The Supreme Court granted a writ of cert. Step 2, the 4 justices agreed to hear your case, and now your case is on the docket. Okay, now before you ever even step foot into the Supreme Court, lawyers for your side and the other side are going to write what's called briefs. Now, these briefs are summaries of their argument, and the idea is that you basically write, I don't want to say a book, but these briefs aren't so brief. But anyway, the lawyers for both sides will write down their argument and why they believe they should win and mail those into the Supreme Court before the case even starts. So that way the justices already know a lot about what the lawyers are going to say and what they believe before they even enter the courtroom. Briefs are very important. Now, anybody can write a brief, theoretically. So if you sue and you take your case to the Supreme Court, your lawyers will probably write briefs. The other side's lawyers will write briefs, but also other groups can write briefs on your behalf or against you. And those are called amicus curiae briefs. I'm not 100% sure if I said that correctly. Amicus curiae briefs. So anybody, only, how should I say this? Only the person that's been harmed can file the lawsuit, but anybody can write an amicus curiae brief, even if you're not directly involved in the case. So here's a great example. In the case of Brown versus the Board of Education, the case that ended public segregation in America, now, obviously, Linda Brown had to be the one to file that case with the federal court, right? She was the one that was personally harmed, but that case mattered to lots of people. So here is an amicus curiae brief from other groups on behalf of Linda Brown, trying to help her lawyers out and help her out by arguing in support of her cause. So the American Civil Liberties Union, the American Jewish Committee, and the Anti-Defamation League wrote this letter to the Supreme Court arguing, hey, here's why we think Linda Brown is right. So it's just a way that groups can help the people that they're in favor of. So amicus curiae literally means friend of the court. So basically these groups are like, hey, we just want to be helpful here. We want to give you some advice on how we think you should decide this case. So they're usually submitted by interest groups. Like, for example, if there's a gun rights case, guaranteed the NRA is going to write an amicus curiae brief arguing in favor of whoever's on the pro-gun side, right? Often they're written by executive agencies, or the Justice Department will often write amicus curiae briefs explaining their opinion on the case. Step 4, now it's time to actually go into the courtroom in front of the judge. It's time for oral arguments. So step 1, you asked the court to hear your case. The Supreme Court issued a writ of certiorari. Step 2, they put your case on the docket with the rule of 4. Step 3, they've already read your briefs. Now it's time for step 4, oral arguments. Lawyers from both sides get their chance in court in front of the justices themselves, and each side gets about 30 minutes to argue their case. And they usually don't have long, so they'll have a prepared speech, but they'll get a couple of minutes into their speech and they'll start getting interrupted by the justices who start asking them questions. So these lawyers have to be really quick on their feet and ready to answer whatever questions these justices might ask. Then, after the oral arguments are over, they go back to that same room where they have their conferences and they talk about the case. And then they vote. Now, in order to win a case, you need a majority. So what's a majority of 9? 5. If you have 5, the most the other guy can have is 4. That's how you win. Now, sometimes a justice will recuse themselves. So let's say, for example, let's say Clarence Thomas's wife is on trial. Well, he should recuse himself, so he can't be a fair juror in her case. He's going to be biased in favor of her, right? So if you know a plaintiff or something, sometimes you have to say, I'm going to sit this one out. So that leaves 4 of the justices. So in that case, it would still take 5 to be a majority, because if you have a 4-4 split, if there's a tie, then basically it's like the case never happened. The lower court's decision stands. All right. Yeah. So if there's a tie, then the lower court's decision will stand. All right. Then, after they've made their decisions, they've made their decision on whose side they're on. Then it's time to announce it to the public, and so they write these opinions of the court. So, for example, in the marriage equality ruling about whether or not gay people should be allowed to get married like straight people are, these were the justices in the majority. There was 5 yeas, 4 nays. So the winning side writes what's called the majority opinion. So one of these five wrote on behalf of all five, explaining why they ruled in favor of marriage equality. I'll get to that in a second. The losing side can write a dissenting opinion. So a dissenting opinion is like, yeah, we lost, but here's why we ruled the way that we did. So they get to have their say too, even though it's not legally binding. It's just the way the losing side can also share their opinion with the country. Now, sometimes one justice might agree, but for a different reason. So let's say and I'm just making this up. Let's say Sonia Sotomayor wrote the majority opinion in this case. Well, maybe Kennedy says, yeah, I agree, but not for the same reason that Sotomayor said. So if you want to write your own opinion, you can. That's called a concurring opinion. We agree, but for different reasons. There's also something called a per curiam opinion, which is like a brief, unsigned opinion. So if it's not like a real big, important issue, the court might just have like a real short, brief, unsigned opinion that's not attached to any justice's name, just signed the court. So that way, none of the justices get any blowback over it. So these opinions are released to the public, and that's it. And then the case is over. So why even bother writing a dissenting opinion? Like, I mean, if you lost, what's the point of wasting all your time writing a big explanation as to why you agreed with the losing side? Well, they want a record of why they disagreed. And remember, there's nowhere you can go if you lose a Supreme Court case, but a Supreme Court in the future might undo this decision. So here's a great quote that kind of summarizes the need for dissenting opinions. Chief Justice Justice Hughes said, "A dissent in a court of last resort is an appeal to the intelligence of a future day. They're hoping to influence future legal opinions to consider their opinion. Even though they lost now, maybe in the future their dissenting opinion will matter." All right, now, how the justices decide these cases is often guided by a principle called stare decisis. And that's a principle that means whenever possible, the Supreme Court tries to let the previous decision stand. So here's a political cartoon, right? These judges sitting around said, Supreme Court's like, I don't know. How did we decide this last time? Whenever possible, the Supreme Court tries to go with what previous courts said. They try typically not to rock the boat and undo older court decisions. Stare decisis in Latin literally means let the decision stand. So often they try to go with what the older courts said. So past decisions are usually followed, but that's not always the case. The Supreme Court, newer Supreme Courts have overridden older Supreme Court decisions over 260 times in US history. Very recently, it was precedent for precedent means past decisions. It was precedent for 50 years that abortion was a constitutionally protected right in America, but that was just changed this year. So this new Supreme Court undid an older Supreme Court decision from the 1970s. But whenever the court makes a new decision or charts a new course, they make a new policy whenever they reinterpret or overrule laws. So, for example, the Supreme Court, by ruling in Dobbs that Roe versus Wade was wrongly decided, means that they've totally changed the way the law works for the people. That can be kind of controversial, but it's a power the court has, and it's the power of judicial review. And over the years, the Supreme Court has invalidated over 160 different federal laws. 160 federal laws have been thrown out by the Supreme Court because the Supreme Court ruled that those laws were unconstitutional. So, how should the Constitution be interpreted? Well, some people believe in strict constructionism. Strict constructionism is where you make your decision based completely on what the Constitution says, based on what's clearly, explicitly written in the Constitution. If it's not in the Constitution, then you wouldn't rule in favor of it. Now, if you have a very strict interpretation of the Constitution, you're going to look at the case and then look at the Constitution very specifically. But if you believe in a loose interpretation or broad constructionism, you will look at the case, and of course you'll look at the Constitution, but you'll also look at other things like the Federalist Papers and other decisions the courts have made, and 250 years have passed since the Constitution was written. You can take into account other factors when you're making your decision. And originalism is probably the most extreme form of constructionism. Originalism is when you're a justice, you take the case and you think, how would the founding fathers have decided this case, right? What would Alexander Hamilton have to say about this? What would James Madison think about this issue? That's originalism. You go back all the way to the very beginning to think about what the founders would have said and go with that. Now, what is the proper role of a judge? Some people believe that judges should have restraint. Some people believe in judicial restraint, that judges, whenever possible, should take a hands off approach and leave the lawmaking to the lawmakers and say, hey, if Congress passed a law, they're the elected branch of government. Let's leave it at that, right? That's more of a hands off approach. That's a more very conservative, not liberal and conservative like Democrat versus Republican, but conservatives and hands off approach when it comes to interpreting the Constitution. So people that believe in judicial restraint believe that the court should just leave the lawmaking up to the Congress. And if the Congress passes a law, then we should probably just leave it alone because that's their job. So people who believe in judicial restraint believe that judges should take a more hands off approach. And by changing what Congress's laws say or the meaning of Congress's laws, they're making new laws instead of interpreting the laws, which is what they're supposed to do. Now, other people believe in judicial activism. So, judicial activists believe that judges should use their power of judicial review to fix things in society and to resolve important societal issues. They believe that the court should, can, and should use their power to overrule the other branches when they believe they're clearly wrong. And if that means creating a bold new policy, like making abortion legal nationally or making it illegal nationally, well, that's okay. That would be judicial activism. So, judicial activism is often used to strike down laws that trample on people's rights or individual liberties. So, judicial activism is often used to um, protect groups that have been oppressed, typically. Like Brown versus the Board of Education was a great example of judicial activism, um, changing the course for people that were not being treated great by Southern governments. So, judicial activism and judicial restraint don't I don't want you to think that judicial activists are liberal like Democrat and judicial restraint is conservative like Republican. It's really not like that at all. It's not linked to politics. It's just about how much involvement the court should have in cases. So an opinion might be called judicial activism for a variety of reasons. So for example, if the Supreme Court made a decision that totally ignored past precedent, you might call it a judicial activist decision. If it's a decision that the court made that undid something Congress did, you might say that that's judicial activism. If it totally reinterprets or reimagines what the Constitution means, you could argue that that's judicial activism. If it appears to be motivated by some social goal or some political goal, you might argue that's judicial activism. All right. So often when it comes to judicial activism, it just depends on what position you take, right? So I love this political cartoon, and so does AP, by the way. So make sure you know this one: the honorable justice versus the judicial activists, right? How can you tell which one is which? Well, it depends on which one you agree with, right? So often people think that the judges that they like are honorable justice, but the justices that they don't like are too activists. But it's not a liberal or conservative thing. If you like the decision, you probably think, oh, that was a great decision. If you don't like the decision, you probably say, oh, these darn judicial activist judges. So I want to tell you three real cases of the court because this shows how that judicial activism and restraint and stare decisis and all this stuff works in a real life situation. Okay. So I want to tell you about Dred Scott and then Plessy versus Ferguson and then Brown versus the Board of Education. So first case, Dred Scott. Dred Scott was born as a slave in Virginia, and the guy that owned him moved from Virginia to Missouri, which was also a slave state. But then he was in the army. He moved temporarily to Illinois, and then Wisconsin. He got stationed in Wisconsin. He brought Dred Scott with him, and then he lived for 2.5 years in free states. But then his owner brought him back to Missouri, a slave state, and took Dred Scott with him, where he went from being a slave. Now, he went let's follow the track. He went from Virginia, slave state, here to Missouri. He stayed a slave, But as soon as he crossed into Illinois, Dred Scott became a free person. That's what his lawyers argued anyway, right? Because Illinois did not have slavery. So a black man was free in Illinois. And the law back then said you could not make a free person into a slave. In order to be a slave, you had to be born a slave. Anyway, So the lawyers argued that as soon as Dred Scott crossed into Illinois, he became free and he could therefore not be made back into a slave when he crossed back into Missouri. And went all the way to the Supreme Court. How do you think the Supreme Court ruled? They ruled against Dred Scott. The Supreme Court ruled not only is Dred Scott still a slave, that he had no right to sue in federal court because he could never be a citizen, and it was one of the most really like over the top, most racist decisions in all of American history. There was the Roger Taney court. Most of these people owned slaves themselves. This decision was so incredibly racist that actually Dred Scott said, sorry, not Dred Scott, Frederick Douglass said it's actually a good decision because this decision is so bad that it's going to encourage people to get off the fence about slavery and choose a side. And hopefully they choose the anti-slavery side. Abraham Lincoln was so disgusted by the decision that he publicly criticized the court when it came out. So I told you that story so I could tell you this story. Okay, so Dred Scott, still a slave. So, what did it take to get rid of slavery then if the Supreme Court said that slavery is allowed and that black people have no rights? Well, the Civil War took care of slavery. Slavery is over. The 13th Amendment makes it unconstitutional to have a slave anywhere in the U.S. Okay, so slavery is no more. Now, that brings us to Plessy versus Ferguson. So, slavery is over. Well, Southern states instituted something called segregation, where there was white accommodations and black accommodations. There was, hotels for white people, hotels for black people. On one train, there would be cars for white people, there would be cars for black people. Segregation, right? Well, here's a case that challenged segregation. Plessy versus Ferguson. Homer Plessy was actually only 1/8 black. He had one black grandparent. He was 7/8 white. But he looked kind of dark, and so he was ordered to sit in the black car. Because back then there was a rule called the one drop rule. If you had one drop of black blood, then you were considered black. And so you had the rights that blacks had, which was not as many as the rights that whites had. But anyway, Homer Plessy was ordered to sit in the colored car because of the segregation rules. And like Rosa Parks later on, he said, I'm not going to go. He got fined. He had to pay a ticket and he sued. He said, hey, I'm mostly white. And also, by the way, segregation is awful. It should be unconstitutional. It went all the way to the Supreme Court, and he argued in the Supreme Court that segregation violates his constitutional rights, and he lost. The Supreme Court ruled against Homer Plessy. The Supreme Court ruled that separate but equal and Jim Crow segregation is allowed. So the Constitution says you can't treat people unequally, but it doesn't say that you can't separate people. So the Supreme Court ruled that segregation is constitutional as long as the accommodations for blacks and whites are reasonably equal. Okay, so I told you about that case to tell you about this case. Brown versus the Board of Education. Now, if the Supreme Court of the United States, the top court in the entire United States of America said in 1896 that segregation is constitutional, then what can anybody do about it? Well, here's the case of Brown versus the Board of Education. 60 years later, there's a case. Here's the deal. There were segregated schools. There were white schools and there were black schools. This is little Linda Brown. She and a bunch of other plaintiffs sued for the exact same reasons. The segregation in schools was unfair and wrong and really unequal. And so Linda Brown lived in Topeka, Kansas, and she had to cross railroad tracks to get to her colored school when there was a white school that was much closer to her home. And her parents were like, this isn't fair. I'm a taxpayer. I'm paying for both these schools. Why can't I send my daughter to the white school that's right across the street? I'm going to worry about my daughter getting hit by a train just to go to school just because of color of skin? That's wrong. It's a violation of the 14th Amendment. They sued and went all the way to the Supreme Court. You know what happened? She won. Brown versus the Board of Education, the Supreme Court ruled that segregation in public schools is unconstitutional, and that got rid of the Jim Crow laws, and it started the ball rolling of desegregating everything in the South. Now, ask yourself this: was that decision judicial restraint or judicial activism? Judicial restraint would have said, well, hey, the Supreme Court already said that segregation is okay, so I guess we're stuck with that. That was definitely a judicial activist decision, but I would argue it was a decision for a good reason. Ending segregation was a good thing to do. It was an activist decision, but activism can be good or bad. It depends on your opinion. If you're pro-segregation, then you're probably like, oh, these darn activist judges. But yeah, so the Supreme Court can make bold changes in American society. If Congress isn't going to do it, if the president's not going to do it, the Supreme Court can make decisions to uphold people's civil liberties and civil rights. So was that an activist decision? Sure. Did it undo stare decisis? Yeah, they didn't follow the principle of stare decisis because they argued that the old Supreme Court was wrong, and so it was appropriate for them to make a change with the decision of Brown versus Board of Education. All right, I hope all that made sense. I will see you in class.